Thank you for starting your day with us. Let's jump to a question right now from one of our viewers. Good morning, Gary. I have a question for you, and I may need to speak with you in person about this. I work as a billing specialist for a large medical group with offices all over Georgia. My job involves sending bills to Medicare on behalf of the doctors so they can be paid. But here's the problem. They are having me bill Medicare for services I know the doctors never performed. Wow. And this isn't just some mistake on their part. They're doing this on purpose. No wonder our health care costs are through the roof. In the 8 months that I've been working there, there is no telling how much money they have had me overbill Medicare. I don't want to lose my job, but I also don't think it's right what they are having me do. What should I do? Do I need a lawyer? Thank you. And her name was withheld upon request. Well, that just makes you mad, doesn't it? If what she says is true, and I have no reason to doubt her, then this medical group is stealing from you. They're stealing from me. Why? Well, because Medicare is a national social insurance plan that pays for medical needs of over 48 million Americans. It is funded by you and me, the taxpayers. So when this medical group sends these bills for medical services they have never performed, they are taking money right out of our pockets. Well, there ought to be a law to prevent this kind of abuse from happening. Well, there is a law. These types of cases are called Qui Tam or Qui Tam. This is an abbreviation for a Latin phrase which essentially means a private individual can assist the government to pursue someone that commits false claims for payment against the government. And if successful, that private individual can share in the recovery. These Qui Tam actions generally revolve around false claims that are either directly or indirectly submitted to the government for payment. Let's talk about some different types of Qui Tam cases. One, mischarging cases. These are the most common ones. These cases involve a contractor filing false claims for goods or services that were not delivered or provided. And this is exactly the type of claim our viewer wrote about in her question. The medical group committed phantom billing. They bill for services they never performed. Second, false negotiations. These are also known as defective pricing cases. In these cases, the contractor submits false pricing and cost data to the government for reimbursement. The government relies on this false data and the contractor gets an inflated contract price. Another one, product or service fraud. These are cases that involve a contractor submitting false certified products to get away with overbilling for substandard supplies or services. And in every one of these cases, we, the taxpayers, are getting ripped off. But let me give you a little history here. The government has always been susceptible to fraud and abuse. For example, during the Civil War, the Union War Department was abused repeatedly by contractors. History tells us that unscrupulous contractors sold the War Department horses and mules that were in ill health. They had defective rifles and ammunition and rancid rations and supplies that they sold the government. So on March 2nd, 1863, Congress passed the False Claims Act. It's often referred to as the Lincoln Law because Abraham Lincoln was the president that signed the bill into law. In the act was a provision that allowed private citizens a reward if they assist in the lawsuit and the government is successful in recovering for the fraudulent actions of the contractor. The government realizes that it is not always in the best position to know if the government's being ripped off by these contractors. Well, in our viewer's question, the government would have a very difficult time knowing that this medical group never provided services to the Medicare recipient. However, the Medicare billing specialist is in a very good position to help expose the fraud. Now let's look at who can file a Qui Tam claim. Under the False Claims Act, the following people can file an action on behalf of the government. One, employees who report their employers for their fraudulent acts. And please note, the act even allows federal employees to do this. And the employees, they are protected from any kind of retaliation by their employers. Two, former employees that have direct knowledge of the fraudulent acts by their former employers. Three, business competitors and or subcontractors that have direct knowledge of the fraudulent acts being committed. And four, state and local governments can also pursue an action under the False Claims Act because of losses the state or the local government incurred because of the fraudulent acts. And five, as I said a little earlier, the act even allows federal employees to pursue an action, and they are obligated under the law to disclose their knowledge of any fraud. Well, whoever pursues the action on behalf of the government is called a relator. You may have also heard them referred to as whistleblowers. Now let's talk about what happens when one of these cases are pursued. If a person has evidence of fraud against the government and he or she wishes to pursue the claim, that person needs to find a lawyer to represent them. The attorney should thoroughly research the evidence to decide whether or not the lawsuit will be successful. And if the decision is made to pursue the case, the attorney will prepare a lawsuit against the individual or business that is out there defrauding the government. This lawsuit is filed under seal, meaning that it is kept a secret from everyone, including the defendant individual or defendant company that is being sued for the fraudulent billing. The U.S. government, through the Department of Justice, will then investigate the allegations, and the government will decide whether or not it will join or intervene in the lawsuit. Listen, if you have any questions about any kind of false claims out there, give us a call. Our phone number is 770-934-8000.